Saskatchewan Premier Scott Moe says he plans to invoke the Notwithstanding clause to protect his government's new school pronoun policy. That policy would require children under the age of 16 to get parental consent to use different names or pronouns at school. The announcement about using the clause came just a few hours after a judge ruled that the policy needed to be paused. An injunction was granted. Scott Moe took some questions about this on Friday.
When those rights collide, the Notwithstanding clause was provided to ensure that the elected government of the day would be able to make the decision on as to which of those rights would be in effect for the people that they ultimately represent. And in this case, that's the rights of a parent to ensure they're involved in their children's decision.
The situation has raised concerns in Ottawa. Arif Virani is the Federal Minister of Justice and Attorney General. Minister Virani, thank you for joining us this morning. Appreciate it.
You're welcome. Nice to be here.
The Premier says that he plans to invoke the Notwithstanding clause to override this injunction. What's your response to that decision?
Well, I thought about this, Rosie, from a number of perspectives. From a perspective as an elected leader who doesn't want to sow division in this country, from the perspective of a parent of two young boys, one of whom is entering adolescence, and understanding that parents want to and have a right to be involved in fundamental decisions in their children's lives, but also from the perspective of a lawyer. And the lawyer in me, Rosie, says that what we heard on Thursday is from a court in Saskatchewan that on a test for an injunction, which is a difficult test to meet, that there's a serious question here, and there's also the possibility of what we call irreparable or irreversible harm to a small set of kids that are very vulnerable. And if I was to receive that kind of decision from a court in my jurisdiction, I think that would give me pause and cause me to reflect on sort of the best steps going forward. And the response from Premier Moe seems to be, instead of pausing and doing that reflection, to sort of press a bit of a fast forward button and go to the end of the discussion and contemplate invoking the Notwithstanding clause.
Yes, go ahead. Sorry, Minister.
What that means is, I mean, the Notwithstanding clause, it's a big flowery term, but it's about overriding charter rights. It's about understanding what you're going to do is to violate someone's equality in this case, and you're going to do so in a way that overrides their basic fundamental constitutional protections. So it's a very deliberate statement, but it's also, from our perspective, something that should be done as a last resort, not as a first volley in a conversation between Parliament and the courts.
I was going to ask you, do you believe that the policy itself violates the Charter?
Well, I think you've heard from the Saskatchewan court, and what they said is, again, on that injunctive test, if they thought that there was no issue here, they wouldn't have granted that temporary stay. So they've temporarily said that policy should not go ahead because of the very serious harm that could be done, including to the mental health of very young and vulnerable children. And we're dealing, Rosie, here with a very small minority of kids. I think people need to understand that. The population of LGBTQ2 folks in Saskatchewan is not large. The population of kids is even smaller. The population of kids that have trouble raising this kind of issue with their parents and with other adults is even smaller. But for that small group, they're vulnerable. And if I know anything about this job 2 months in, is that I'm sworn to uphold the Constitution and the Charter, and that means protecting equality rights, protecting human rights, and protecting those who are vulnerable. That's what I will always stand.
Though the Notwithstanding clause is a province's right. They have a right to invoke this clause, and what Premier Moe says is that he believes that the policy has widespread support in the province, and he also said, quote, the default position should never be to keep a child's information from their parents. So if he believes that fundamentally this is supported in the province, why should he not go ahead? Why can't this be tested sort of politically in terms of what he's comfortable with?
I think, again, when you reflect on sort of that decision, what I think it requires us to do, particularly in this climate, is to sort of be listening, right? And right now, there's a lot of division in Canada. There's division, there's polarization, there's division. And where that leads to is intolerance, sometimes hatred, and sometimes violence. You and I have talked about this in the past. Yeah. And in that context, I think we need to be listening to each other and not curtailing the conversation. It's not an easy exercise. It takes time, it takes patience, it takes openness. But when you insert a blunt instrument, such as a Notwithstanding clause, what you're doing is saying, I don't want to have that discussion. I don't want further guidance from the courts. I'm going to put my foot down and say that this is happening no matter what the courts say, no matter what other vulnerable communities think. And that to me is problematic. Is this a legal instrument that's available? Yes, it is. Do I firmly believe, does our government and the Prime Minister firmly believe it should only be used as a last resort once all of these conversations, these difficult issues have been addressed? Yes, it should be a last resort only. The fact that it's the first word in the conversation and Premier Moe is also using it as the last word, to me is troubling, and I think it's troubling a lot of Canadians.
Okay, so what is your government going to do about it? Because I would point out, Minister, that Quebec also uses the notwithstanding clause sometimes as a first resort and not a last one. And there are things that the federal government can do here. You could be an intervener, would be a starting point. What is the status of the position there?
Okay, so the first thing I'm going to do is exactly what I'm doing now, which is speaking up for the Charter and for the defense of minorities. The second thing I'm going to do is I'm going to follow this case very closely. I mean, Rosie, you know me well enough to know that I'm not going to speculate about intervening in a case that doesn't exist yet because the law itself has not even been enacted. So that's
no,
a
but you are.
question.
Well, you're here doing an interview about the clause not being invoked. So it's only fair that I would then be able to ask you what your position will be if it's going to be invoked. The whole premise of the interview is hypothetical under that idea. So will you seek intervener status if it goes ahead?
We don't know what's going to happen. We only know what Premier Moe has threatened to do. And what I'm saying is in response to Premier Moe's public comments over the past several days that I'm concerned, the Prime Minister is concerned. I'm going to follow the case very closely. And I'm going to try and encourage all Canadians to get to the point where that division that we're seeing is not so rife, right? To me, the best evidence in Canadian society is that it's when we're standing up for each other as opposed to pitted against one another, when men are standing up against misogyny, when non-racialized people are standing up against white supremacy. My response to Scott Moe is not directed at Scott Moe, Rosie. My response would be the same to any premier in any province, whether it's a racial discrimination issue in BC or a religious discrimination issue on the East Coast. The bottom line is that I see my role, and the Prime Minister has empowered me to defend the Charter and defend minorities. That's what I will always continue to seek to do, and I will always continue to seek to bring premiers to view things from the same lens.